Yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, gentlemen, and welcome to the morning session of the Tennessee Court of Appeals. I know this is not the way you normally come to the Court of Appeals, but we certainly appreciate you participating as we try to do our best to continue to work through this pandemic. We've spent a great deal of time thinking about this and believe that this is the best way to keep everyone safe as we try to negotiate these uncharted waters. And we, first of all, want to tell you how much we appreciate you participating in this video oral argument. I want to take just a moment to introduce the panel and talk about the rules that we're going to follow generally. First of all, your panel this morning will consist of Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. All of you are experienced practitioners and you've been here before, so you know sort of what we do. Each side gets 15 minutes to make its oral argument. If there is more than one party to a side, you will need to have decided how you're going to split your time if both of you are going to argue. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time, but you'll need to request that from the court after you introduce yourself and before you begin oral argument. Want to thank Mr. Hibner. He has been just fantastic in putting all this together. He didn't understand that that was part of the clerk of the court's duty when he took this job, and nobody understood that, as a matter of fact, but he and his staff have been wonderful in putting these video oral arguments together. I want to also thank the AOC staff. The technology people have amazed me and continue to amaze me on a daily basis. They work hard and do a wonderful job. So also, gentlemen, you understand that this is live streaming, and I don't know how many people are watching it, but anybody who wants to watch it has the ability to. So without further ado, Mr. Hibner, if you'll call the first case, please.
In Re Treylynn T et al.
All right, we will hear from the appellant.
Good morning, and may it please the court. My name's Sam Henson. I'm here on behalf of the appellant, Miss Angel Taylor. This time I'd like to request 3 minutes for rebuttal.
All right, sir. You may begin your argument.
Thank you. Your Honor, this case arises out of a severe dependency and neglect petition filed by the Department of Children's Services. And it's dealing with a young child, an infant child, who sustained some head injuries. Department of Children's Services has alleged that the child's head injuries were caused by non-accidental abusive head trauma. And that is the finding that was made by the juvenile court and subsequently the circuit court of Henderson County, Tennessee. However, the finding of severe dependency and neglect by the circuit court should be overturned or reversed, or the alternative remanded, based on 3 reasons. Number one, the state at the de novo hearing failed to present clear and convincing evidence that Ms. Taylor should have known or knew or should have known of the occurrence of child abuse. Number two, the court erred in relying on Ms. Taylor's best interest plea. And number 3, every allegation in the petition for dependency and neglect, if taken as true, the conditions that allegedly existed at the time the petition was filed did not exist at the time of the de novo hearing. Your Honor, regarding the clear and convincing evidence standard, I think the state in their brief correctly provided or provided a very detailed definition of that standard, which states, evidence satisfying the clear and convincing evidence standard establishes that the truth of the facts asserted is highly probable and eliminates any serious or substantial doubt about the correctness of the conclusions drawn from the evidence. Your Honors, at the de novo hearing, in the present case, at the de novo hearing, Michelle Stevens, who was the investigator for the Department of Children's Services, was called to the stand. And she testified about the body of evidence that the state of Tennessee had in this case. And she testified that she removed Miss Taylor's children based on her conversations with doctors from the Vanderbilt Hospital and a doctor by the name of Lisa Piercy. She also, however, testified that all the doctors from Vanderbilt could tell her about the injuries that this young child received were that those injuries were suspicious. They couldn't tell Ms. Stevens how the injury occurred. They couldn't tell Ms. Stevens when the injury occurred, who caused the injury. They just stated it was suspicious. She then talked, after speaking with Vanderbilt, doctors from Vanderbilt, she spoke to Dr. Lisa Piercy. And this is perhaps what I would consider to be the most concerning issue or the most troubling issue with the state's case, because Ms. Stevens testified at the hearing that, yes, she talked to Dr. Stevens about the injuries, or Dr. Piercy about the injuries. But at the time of the de novo hearing, she had not read Dr. Lisa Piercy's deposition transcripts, which were taken, her deposition was taken in this case. At that deposition, Dr. Piercy, who reviewed the medical records and reviewed the case file, she stated that she could not come to the conclusion that these injuries were non-accidental abusive head trauma. In fact, she stated that she could not conclude within a reasonable degree of medical certainty that these injuries weren't caused by an accident. And those two opinions from those two doctors literally embodies the state of Tennessee's case. And it is our position, it's our argument today that one doctor's suspicion and another doctor's complete inability to conclude that these injuries were abusive doesn't even come close to the clear and convincing evidence standard. It certainly does not make the truth of the assertion or the facts asserted in the petition highly probable, and certainly does not eliminate any serious or substantial doubt about the correctness of the conclusions drawn from the evidence. What we're faced with here, Your Honors, is a case where a mother's children were removed from her, taken from her custody, because one doctor felt that the injuries received by one child was suspicious. And they didn't take into account the fact that when this child was born with head injuries. The young child had a brain or a skull fracture when she was born. There was no injuries, physical injuries on the skin or the head of the baby that would indicate anybody had caused any injury to her. From the moment this case started up until today's date, the state has failed to provide any evidence other than one doctor's opinion that this is suspicious. And based on that, it's our position today that the state just failed to meet the clear and convincing evidence standard. At the de novo hearing, despite making that argument and despite that evidence being presented at the de novo hearing, the circuit court relied and stated that it was going to look back in time at what happened previously in this case and rely on Ms. Taylor's best interest plea that she entered. And that brings up my second point. In July of 2018, Ms. Taylor, acting on the advice and quite frankly, the bad advice of her public defender, entered a best interest plea to misdemeanor child endangerment on this case. She was placed on diversion. She successfully completed that diversion, meaning that the case was dismissed. And I submitted prior to the de novo hearing a case that was from this honorable court back in 2016. It's the case of Re Treylynn H. And that's a similar case to this in that there was a DNN petition filed. Now that case dealt with drugs. This case deals with abuse, but there was a DNN petition filed. And in that case, the mother stipulated to the allegations in the petition, both in the juvenile court and in the circuit court level. She agreed and admitted that the allegations raised by the state of Tennessee were true. And based on that stipulation, the court in both the juvenile setting and the circuit court setting upheld the finding of dependency and neglect. That case was appealed to this court, and this court stated that the de novo hearing requirement, this court held that the circuit court erred in finding dependency and neglect based on the mother's stipulation, and in coming to that ruling stated the de novo hearing requirement directs the circuit court to determine whether the child is dependent and neglected as of the time of the new hearing. If the conditions of dependency and neglect do not exist at the time of the hearing, the circuit court must dismiss the petition. And that sort of ties into the third point in my brief, Your Honors, that the condition—
What do you say is, Ms. Henson, what do you say is missing in that analysis at the time of the hearing? What's different?
Yes, sir. So when the petition was filed originally, Miss Taylor was living with Mr. Crutcher, who was the father of the children. She had a job in the medical field. And when the petition was filed, the Department of Children's Service requested that she completely remove Miss Taylor or Mr. Crutcher from her life. She lost her job as a result of this, so they requested that she get a new job. They've requested that she complete alcohol and drug assessments, counseling, a whole host of different hoops they have requested that she jump through. And she has jumped through every single one of those. At the time of the de novo hearing, there were no allegations whatsoever that the children were in any danger. Of course, they were in foster care. But at the time of the de novo hearing, she had successfully completed her diversion. She had successfully acquired a new job and has one now back in the medical field. She's completely removed Mr. Crutcher from her life, and she's doing as well as she was doing when the petition was filed.
Was the charge expunged? Was the charge expunged after
Yes, sir.
she completed diversity?
Yes, Your Honor. My understanding it was. I didn't represent her on that, but my understanding it was expunged.
So what is the significance of the best interest plea then?
Well, we would argue that there's no significance to it, but the court
Let me rephrase the question then. What's the legal significance of it according to the law as it now stands?
Yes, sir. So she entered the best interest plea. The court, as the law states, can still treat that as a guilty plea, but not as an admission of guilt, but can still treat it as a guilty plea. And that's exactly what the circuit court did, and stated as much, that it was going to look back in time. It was going to rely on that best interest plea because the law says the court can treat it as a guilty plea.
Why is that not res judicata as any other plea would be in that type situation?
Well, and I think the problem with that, Judge, is that and of course, relying on the cases that I've submitted dealing with this, I guess the best way to answer that would be in the Re Treylynn case. That was a stipulation, a direct admission of the allegations from the DCS petition. This is not the best interest plea that Ms. Taylor entered was not a direct admission of the allegations raised in the DCS petition. It wasn't an admission at all. It was just her stating, I'm not going to fight the case. I'm not going to risk the jail time that might occur if I lose a jury trial.
Sure, but I mean, that's what every best interest plea is, isn't it? It basically says, I'm not admitting to it, but I think you can prove it and I'm not going to fight it. Yes,
sir. That's correct. But when we look at this court's opinion from the Re Treylynn case, this court stated in Re Treylynn that a circuit court cannot rely solely on a stipulation. And I would argue that best interest plea does not even rise to the level of a stipulation, because on the one hand, you've got somebody directly admitting that the allegations are true. That's not the same as entering a best interest plea to a misdemeanor version of those allegations.
Well, let me ask you, in the Landon case, didn't the mother simply stipulate that at the time that the children were taken, that the children were dependent and neglected, and then the trial court heard no other proof? But in our case here, the trial court made a determination at the time of the hearing that the children were dependent and neglected. Also, keep in mind, the Supreme Court in the Albright case says that an Alford plea is an admission that can be used in a civil matter. It is an admission.
Yes, sir. And I that's exactly correct. It is an admission, but I think the distinguishing, or can be treated as admission for certainly, but I think what's the difference there is that on the one hand, you've got a direct admission to the allegations. Ms. Taylor has not done that. She just simply entered that best interest plea to misdemeanor child endangerment. But if you go by the allegations in the petition from DCS, that's not misdemeanor child endangerment. That's severe child abuse that they've alleged against her. So she's not admitting that what DCS said is true. She's just taking her best interest.
It gets to be severe child abuse because she admitted to child endangerment, and then the injuries to the child were life-threatening. That's what makes it severe child abuse. And we know that the injuries were severe based on the medical depositions and also based on the father's plea to the charge of severe child abuse.
Yes, sir, that's correct. And I'm out of time.
That's okay. Go ahead and answer the question.
Yes, sir. So and that's right. Your Honor stated that exactly correctly. But I would say that the difference in sort of the analysis there is that Miss Taylor's case was dismissed. It was she was diverted of these charges, and the court in the de novo hearing just only took into account the facts of the best interest plea and did not take into account the conditions that existed at that hearing, which I believe is what in Re Treylynn and the other cases I've cited directed the court to do.
Okay, thank you. You've got your rebuttal time, and we'll hear from opposing counsel now.
Thank you, Your Honor. May it please the court. My name is Jordan Cruz, and I represent the Department of Children's Services in this appeal.
Let me ask you a question before you get started. Are you and Mr. Anderson sharing any time?
No, Your Honor. I'll be presenting all of the argument. Mr. Anderson is the guardian ad litem and is just attending.
Okay, thank you.
Yes, Your Honor. Thank you. First, I would like to address opposing counsel's argument that there was really no evidence of non-accidental trauma in this case. The reality is that there was much more than that. The doctor whom Mr. Henson was referencing earlier, Dr. Copenhaver, was on the care team at Vanderbilt. She provided a medical assessment of the child at issue in this case. And she found, she found that the subdural hematomas suffered by the child were, quote, highly concerning, that they were a result of non-accidental head trauma. She also found that there was no medical cause for these injuries, there was no accidental mechanism for these injuries, and that the injuries could not have been the result of the child's own actions or as the result of birth trauma. We also had deposition testimony from Dr. Piercy, who was deposed in this case as the expert physician. She reviewed the file. She also testified that the injuries were concerning for non-accidental head trauma. She went through, and as Mr. Henson acknowledged, she did state that she couldn't say within a reasonable degree of medical certainty that the injuries were caused by non-accidental trauma, but she also had no knowledge of the child after she was discharged from Vanderbilt Children's Hospital. And that was before Dr. Copenhaver had completed her medical assessment of the child. So from Dr. Piercy's deposition testimony, it looks like she didn't have a chance to actually review the medical assessment of Dr. Copenhaver that found the child's injuries highly concerning for non-accidental trauma. So there was more than sufficient evidence to show that these injuries were caused by non-accidental trauma. And I would next like to move on to the issue of whether the circuit court was right in relying on the mother's best interest plea in finding that she knowingly failed to protect this child from the father's abuse. As Your Honor noted earlier, the father did plead to aggravated child abuse, and he was currently incarcerated at the time of the de novo hearing. And as far as mother's best interest plea, the Supreme Court recently held, or at least acknowledged, that a best interest plea can be used as an estoppel mechanism for the criminal defendant in subsequent civil litigation. And that's exactly what
is that the same even if that charge has been diverted?
Your Honor, I think it is, Your Honor. It's still a best interest plea, and I'm not too familiar with the criminal law, to be frank, Your Honor. But I would imagine that a lot of the best interest pleas result in a diversion and ultimate dismissal. But in order to get the best interest plea, the defendant has to admit that the evidence that the prosecutor has is likely going to result in a guilty conviction. And that's what we have here. Although the mother in the best interest plea, maintains her innocence, she has admitted that the evidence is strong enough that she will likely be convicted of this charge. And so we have another case, I believe it's from this court, Your Honor, that says that a guilty plea can be used as it's competent evidence as an admission against interest, and that's what we have here. An offered plea is a guilty plea, as stated by the Tennessee Supreme Court. And a circuit court in a severe child abuse case can certainly use that can rely on that as competent evidence of severe child abuse, in that the mother knowingly failed to protect the child.
I understand that. I'm just, my concern is the diversion itself. I think Judge Golden asked Mr. Henson if the plea had been expunged, and Mr. Henson indicated it had. So consequently, if you were to look back now to try to find assuming all that's correct, and assuming that's in the record, if you were to look back now to try to find that conviction no longer exists if what Mr. Henson is saying is correct. So how does that play?
Do we know
that is true.
do we know it even existed on the date of the hearing?
Well,
whether or not it existed on the date of the hearing, do we know whether it could have been expunged prior to the date of the hearing? I don't know what difference that would make.
Well, it certainly wasn't expunged by the time that the parties, or that the department, the DCS, got access to those documents. Otherwise, those documents wouldn't have been there to access. And in the record, I didn't see anything in the record stating that this conviction had been expunged. There is a diversion agreement, but I'm not sure about the expungement.
Does it make a difference if it's been expunged or if it's just simply been diverted? And I realize I'm hitting you cold, and you have already said you're not that familiar with criminal law. So it may not be a fair question.
Well, Your Honor, like I said, I can't say for certain, but I don't see why it would matter if it's expunged, because if there's something on the record that says this person entered a best interest plea, obviously the court, and if it's properly included in the record, then the court can say, well, you entered this best interest plea for purposes of the civil matter that's in the Michigan's interest, and I'm going to use that to find against you. I think that's perfectly appropriate for a court to do in a civil case. And I would like to move on to the dependency and neglect finding by the circuit court. Mr. Henson's argument about that, was essentially that the mother had done everything that the department had asked her to do. And so at the time of the de novo hearing, there was no dependency and neglect. Well, it may be true that she jumped through all the hoops that the department wanted her to do, but there's one crucial thing she didn't do, and that's ever admit that the child was even abused by anybody. Even after the father even after he pled to aggravated child abuse, and even after the mother knew that.
Let me stop you there on that analysis. Sure. Didn't she actually do that when she entered her best interest plea?
Did she admit that? Well, yes, she did. But in the subsequent, in her testimony at the de novo hearing, it was different.
Assuming your argument is legally correct, the entry of the best interest plea to the misdemeanor offense is res judicata. And that's something that can be used to say, does she even have to admit it at that point in time? I understand she didn't, but I guess I'm trying to figure out which point is, other than she's not taking responsibility.
That was my point, Your Honor. Just that there's no responsibility taken here. She did enter the best interest plea, and of course that comes with her, her saying that I'm going to protest my innocence here. But I admit that the facts are not good for me. And she maintained that at the de novo hearing. She was asked, that the father pled to aggravated child abuse. Yes, I know that. There's no other medical explanation for this injury. Yes, I know that. Do you still believe that this child was abused? No, I don't. That's essentially what she said in her testimony at the de novo hearing. And so I think that, in conjunction with the actual statutory language of the dependency and neglect statutes, it's clear that the fact, that this child has sustained abuse, even though it was in the past, does not, foreclose a dependency and neglect finding at a later date. Otherwise, severe abuse will never be a proper basis for finding dependency and neglect. If you can just go back and say, yeah, I abused this child a year ago, 2 months ago, but I'm not abusing her now, so there's no dependency and neglect. And that's essentially what I've gathered from the mother's brief in this case, Your Honor. And I believe that's all I have. If there are any further questions, I would be happy to answer those.
Let me ask you, how do you distinguish the Landon case that Mr. Henson relies on?
Yes, Your Honor. Well, the Landon case doesn't deal with severe child abuse whatsoever. What the Landon case did, and the proposition that the mother relies on, is that the mother or a parent can't simply stipulate to dependency and neglect at the time the petition is filed, and the court can't rely on that in finding dependency and neglect. That's essentially what Landon H said, and so this court vacated or remanded back to the trial court for another hearing, I believe. I can't remember exactly, but that's not this case at all. We have a severe child abuse finding here, and it's just entirely distinguishable from what's going on here. And I believe there's the other Green versus Green is the other case I believe that the mother relied on, and that's essentially the same thing. It was a dependency and neglect case, but it didn't deal with severe child abuse at all, Your Honor. They're just completely distinguishable cases from what we have here. And for those reasons, Your Honor, I'm sorry. I was just going to ask you to affirm the judgment, Your Honor.
Okay. All right. I'm sorry. I didn't mean to cut you off.
That's okay. Thank you.
Yes, sir. Mr. Henson, we will hear from you in rebuttal.
Thank you, Your Honor. Just to touch on opposing counsel's argument, the cases that I've submitted, all three of them, the N. Ray Landon case, the Green case, and then N. Ray Melissa MS, they all say the same thing. And that's that at the de novo hearing, the circuit court judge is supposed to look at the evidence that's presented to him that day, him or her that day, and not go back in time and rely solely on the juvenile record that has occurred. But that's precisely what happened in this case. The circuit court made.
Isn't it true, though, that the circuit court can rely upon the juvenile record and the findings of fact and conclusions of law made by the juvenile court in its prior determination?
Yes, sir.
That's part of the record.
Yes, sir. And that's what the N. Ray Melissa case stated, is that it can rely on the juvenile record, but it can't solely rely on the juvenile record. It has to also, in trying the case de novo, render an independent decision based on the evidence received at that hearing. And the evidence received at that hearing, which is precisely, I'm sorry.
What suggests that the trial court in this case didn't rely on the proof at the hearing?
At the conclusion of the hearing, Your Honor, the judge stated that he was going to look back in time and rely on the best interest plea and based his ruling on that best interest plea.
Well, didn't he also have the medical depositions as a part of the hearing?
He did, Your Honor, but I don't believe the court relied on it. I think the court took the testimony that was heard and the evidence was presented, but didn't rely on it. The statement made by the court at the end of the hearing was that it was relying on the best interest plea that was entered and was going to look back in time, and made no mention of the evidence that was presented that day at the hearing, which was zero. It was the same thing opposing counsel just said. One doctor's opinion that the injuries were suspicious. And suspicion in our justice system never should be equal to highly probable, as the definition of clear and convincing states.
Did Dr. Piercy not say that the injury was likely caused by inflicted head trauma?
Well, I believe she stated that that's certainly a possibility, but she couldn't rule out non-accidental trauma either. And that's what's important is you've got two doctors here. One says highly suspicious. The other says, I can't rule out an accident. And then when you compare that to the definition of clear and convincing evidence, they just don't equate to each other. Because even Dr. Piercy could not eliminate any serious or substantial doubt about the correctness of the conclusions drawn from the evidence, because she couldn't conclude that this was not caused by an accident. And my timer's not up, so I don't know if I'm over my 3 minutes or not.
You're fine. Go ahead.
Okay.
Finish your statement.
And regarding the distinction that opposing counsel stated between the N. Ray Landon case, it is a regular DNN case, as we say, but I didn't read anywhere in the opinion where it made any distinction between a DNN case and a severe DNN case. So I don't believe there is a distinction. It's a distinction without a difference, rather.
All right, sir. You have used your time. Counsel, we appreciate your argument. We will attempt to get you an opinion at the earliest possible date. Mr. Anderson, I know you didn't argue, but appreciate you being here and participating in this. Again, we want to thank Mr. Hibner for all his hard work in putting this together and the AOC staff. And that will conclude this case. Mr. Hibner, if you will call the docket so we can take up the next case.
This honorable court is now in recess until 10 a.m.